Hello and welcome to the Ken Vercammen Law Office Legal Podcast. This week we're talking about the administration of an estate. So an administration is where someone passed away, they don't have a will, it costs a lot more money and it's more work, but people, they don't have a will, they don't have a will. So logistically, for example, if there's 3 kids, if all the children agree upon who's the administrator, the ones who aren't going to be the administrator have to sign what's called a renunciation for administration. It's signed in front of a notary and it gets filed with the surrogate together with a fee. Most people have an attorney assisting them when it's administration because it's a little bit more complicated. So the different surrogates' office have an information sheet. So you have to list name of the decedent, the address of the person who passed, date of death, date of birth, social security number, the name and address of the administrator, telephone number of the administrator, and it's a good idea to include an email. Then who's the next of kin? So if there's 3 children, it's just the next of kin. If one of the children passed, then it's their kids who will be the grandkids. Then you got to list the value of the estate, and then there's a what's called in many counties administration certification of assets. So let's say the person who wants the administrator is going to list cash on hand, stocks, bonds. If there's life insurance payable to the estate, not to individual persons. Is there a house? Where's the real, and it's only real estate in New Jersey. Then there's what other assets the person has that do not have. It's only assets that don't have a direct beneficiary. Then the person has to be bonded when there's no will. You have to contact bonding companies. Someone with bad credit may not be able to get bonded. Which is another reason to have a will, because most attorneys will put a clause in a will that says no bond required. After someone's bonded and they pay the fees to the surrogate's office, they obtain what's called letters of administration. When there's a will, letters testamentary. But if all of those beneficiaries don't agree, then there has to be a complaint or to show cause filed in the Superior Court. For more information on administration, visit website njlaws.com. And for representation, contact Ken Vercammen's office at 732-572-0500. Thank you.